I'm Gary Forster.
Hi.
I'm here with Eric Bowman. That way you get the planning and the screaming, so you get both the planner and the litigator. Today we're gonna focus on something a little more specific, and that's the major weapon of the creditor with respect to really any significant collection action. Not so much someone suing someone to break through or get to them, but the real strength in the arsenal of the creditor attorney to unwind a protective transaction. So on the next slide, you can see we're going to walk through a couple of the different aspects to the fraudulent transfer law and how it could implicate a variety of situations. Fairly practical. You're going to find that a few things kind of thread throughout the asset protection / fraudulent transfer body of law, and a lot of them have to do with valuation and insolvency. So although there may be 50 factors associated with a fraudulent transfer, the lawyers are really focused a lot on valuation, insolvency, and intent. So let's start with the first aspect, which is an introduction. Go ahead, Aaron.
All right, so and this just gives us an overview of what we're going to talk about today, just so we have a little bit of a roadmap. As Gary mentioned, a big part of the focus will be on the fraudulent transfers, and we'll talk about a little bit about that law, try and throw in some interesting factual scenarios, and then defenses to the fraudulent transfer. Initially, where we start with respect to assets generally and asset protection and what your rights are. And this question comes up, at a basic level, is what are there limits on your right to transfer assets? If I have a fraudulent transfer deals with transferring assets away from the grasp of a creditor or a potential creditor. So if you have a creditor, if you have a claim, or if somebody's made a demand, are you restricted from transferring assets? And what about generally? If you don't have any outstanding judgments or claims, what are the limits of transferring assets to into entities, trusts, friends and family members, charities, etc. And the U.S. Supreme Court spoke to this, and this is the case that we all start with. This is a late 90s case where the court basically said that prior to judgment or a claim, assets can be freely transferred. Now, what we'll find as we sort of walk through the next hour is that determining what a claim is and who holds a claim isn't always that clear, and that's where we get into some of the gray area that makes for interesting discussion.
And it's also so this is a general idea that the English common law and American law says you can move whatever you want whenever you want. That's the overriding rule. So there's no real inability to move assets. One exception may be if you have a creditor that's a governmental entity or there's some kind of criminal aspect to it involved, where the repercussions would be other than just fraudulent transfer, unwinding the asset, going to get the asset. So although the general law allows you to move whatever you want, whenever you want, there are some special rules. We want to make sure everybody's totally aware of that. That if you're dealing with like the IRS as a creditor or you're dealing with the FTC as a creditor, there are other rules implicated by transferring things away from the government. Let's go to the next slide.
So generally, and Gary touched on some of this, to the extent that you are limited in transferring assets, there's usually going to be exceptional circumstances. So you can generally transfer, you have a right to transfer and move your assets and do with them what you will, and courts cannot impede that, subject to certain rights of creditors to enjoin what are fraudulent transfers. That means prohibit further transfer of transfers that a creditor is able to prove up as a fraudulent transfer, or to attach, essentially, similar to putting a lien or a garnishment on an asset that's been transferred by a debtor.
But it's fairly difficult. It's fairly difficult.
it's difficult. There's a high burden in order to obtain these remedies prior to judgment. The court will require a hearing and will allow the debtor to be heard. And if the court does enter such a remedy that prohibits, again, prior to judgment, if a court enters a remedy that prohibits a person or a company or any debtor or potential debtor, a defendant in a lawsuit from moving assets, the court will require the plaintiff to post a bond, and the purpose of that bond is to provide a fund from which the defendant can collect if the court later determines that the injunction or prejudgment remedy was entered improvidently. So there's a risk there if you're a creditor and you want to obtain a prejudgment remedy. You have to, either through a bond company or through cash, put sufficient money into the court registry that would pay for attorney's fees and any damages that a defendant suffers if the court later finds out that you move too aggressively. And again, criminal action, governmental action, these all would fall into exceptional circumstances, again, where you really need to be careful and probably get counsel involved. So now, with that general backdrop of the right to transfer assets, we talk about those limited by fraudulent transfer implications, and so we'll go into a pretty detailed discussion today on fraudulent transfers.
This is really the topic of our seminar. Once someone exercises their right to transfer, what can the creditor do? And you'll see that it surprises most clients and financial professionals that it's not a penal statute. It's not something where if somebody who's subject to a creditor transfers assets, that they're subject to some kind of penalty. The statute is remedial, which means that it would permit the creditor to come in and find the asset. In other words, if it went to the defendant's cousin, the cousin would be brought into the case and the asset extracted basically from the transferee if a fraudulent transfer could be proven. And the basis of our national fraudulent transfer rules, it's state by state, except for some of the federal government rules, is the Uniform Fraudulent Transfer Act. It does, as Eric alluded to, permit the creditor to unwind the transfer, which now the creditor finds that the asset is now in place that they can't reach. It's held by a party who's not part of the lawsuit. It's inside an asset protection trust. Wherever it is, it was transferred, right, to avoid a creditor. So the idea of the Fraudulent Transfer Act is that the defendant moved the asset with the intent to avoid the creditor. So you're always looking at what were the debtor's intentions when the asset was transferred, and is the creditor entitled to the benefits of the Fraudulent Transfer Act? Is the creditor protected? And we're going to work you through the steps of that now.
All right, Alan, we have a question already. Excellent. We got an active audience today. The question is, do you need to file a lawsuit to be deemed a creditor? And this is a timely question because, as we'll discuss as we go forward, determining who is a creditor is not always clear, according to both the statutory law and the case law. But the short answer is no. You do not have to file a lawsuit. In fact, creditors can be someone whose debt is a contingent debt or arises in the future, and we'll talk about that in the next couple of slides. And by the way, today we like the participation. We really like to do these presentations in person, but we also find that people find value in being able to be in their office and participate in a webinar. If you have a question, you drop it into the box. We'll read off the question, answer it, and we will send you a copy of Gary's book on asset protection. So you get a freebie today if you participate with a question. So moving on, and following up on that excellent question, we have a discussion about, who does the Fraudulent Transfer Act apply to? And this is back to creditors. It's future creditors, contingent creditors, and existing creditors. And this is anyone, generally speaking, to whom a debt is owed, regardless of whether a lawsuit's been filed or a judgment's been entered. So a bank, as a bank who has a borrower is a creditor. A loan guarantor would be a contingent debtor, so that would be a contingent debt. A creditor whose claim is disputed would still be considered a creditor, although there's questions.
And those are your existing creditors who are clearly protected, most in general clearly protected.
That's right.
When it becomes interesting is trying to figure out who is a protected future creditor. In other words, a future creditor is someone who has the legal right to collect or supposed legal right to collect on the debt after the transfer. So some kind of a factual scenario exists whereby, oh God, the surgeon left a scalpel in the body, or some kind of, there was an accident, right? But the plaintiff or the potential plaintiff isn't yet really a creditor. We don't really know what's owed, but there's something that happened, and that might be a future creditor. We don't. It's incredible that this law has been going on for 500 years, and we had written an article 6 or 7 months ago in the ABA Journal. We still don't know who a future creditor is. We thought for years before about 2004 that we could plan in terms of asset protection planning for someone who has no present creditors and no future creditors, based on the assumption that a future creditor was someone we could expect to make a claim. In other words, something occurred, we do our planning, we do transfers, and then later the lawsuit comes or the debt arises based on something we know about. So it's someone we would expect or have a reasonable expectation that they would become a creditor. But the law, even the new law, which we'll talk about later in the seminar, doesn't say that. It just says a future creditor. That really needs to get resolved, and we'll talk more about how that can get resolved in a few minutes. But it's an interesting aspect that leaves this fraudulent transfer claim open.
So there's a lot of gray area, and we talked about this in our last seminar on when you engage in asset protection, tying it in with other purposes, because we really at this point, as we'll see, we'll talk about a couple cases to give an illustration of this. But if a certain court finds that a debtor has transferred assets with the purpose of moving them away from the grasp of creditors, even if it's a future potential creditor that's nowhere on the horizon and not known, in some circumstances the debtor can run into trouble. So let's jump to the next slide, and we'll use two examples here. And the first one is a case that we've talked about before, Kirby Stillman. This was a California case. And what's interesting here is that Stillman was an engineer who did work in site prep for some swimming pools, and years after he did the work in 2000, 2004, he engaged in some asset protection in Nevada.
No claims.
With no claims,
no knowledge,
no reason
problem
to think that there was anybody that was going to come knocking on his door. And it wasn't until several years after that, 2008, that he was that Stillman was sued. And so the question is, well, okay, he engaged in asset protection, but he did it with no claims or creditors on the horizon.
So the general view of that is that that's how asset protection planning works. Someone comes in, they form a structure, or they buy exempt assets, or both, typically both, and they fund the structure. There's no existing debt. There's no one on the horizon. In other words, they couldn't reasonably expect someone to sue them on a claim. And they fund the structure. We thought that was a clear asset protection planning, rock solid way to establish a structure. Unfortunately, when Stillman was in California, that was the first unfortunate problem. But Stillman also owed a lot of debt. He wasn't really strong as a witness. He was a little tricky with the court. And he became the sole, I think he was the sole beneficiary of his asset protection plan. So when he created trust, there was nobody else. He wasn't really aiding anybody else, so there wasn't anybody else part of the plan, which is a mistake. And he didn't really do any other planning as part of his asset protection work. Honestly, it shouldn't have made any difference. I mean, he had really no future creditors that he could think of. But the court kind of went off the rails and said, well, because your sole purpose was asset protection planning, you had the intent to avoid creditors. So the first way to do it is just to actually prove that their frame of mind was to avoid the creditor, which is very, very difficult, especially if there was any estate planning or other intentions associated with the transfer. It's hard to show that someone was intending to avoid you. It seems more simple than it is, but to actually show someone's frame of mind is very difficult. So you get into the constructive intent. Constructive means that if you prove these things, it doesn't matter what they were thinking. Interestingly enough, if someone was not intending to avoid the creditor and constructive intent is proven, it doesn't matter. It doesn't matter what they were actually thinking. And Eric had mentioned that there are present and future creditors, and the constructive intent cause of action, the elements differ somewhat for the present and future creditors. We have it on the slide here. Basically, if you're either a present or future creditor, you just have to prove the failure of the transferor to receive equivalent value, and that value issue is threaded throughout this area law, and incurred debt beyond the debtor's ability to pay. What that means is move the asset out, and at that point they basically couldn't pay back the debt. Okay? Now there's also an element here where they engaged in a business with an unreasonably small amount of assets. It's very rarely touched upon, and it's extremely ambiguous, actually. You could fund a business as just kind of an act to bury assets is basically what that amounts to. So present and future creditors, they transfer something out, they don't get value back, right? So you're suing someone, they have a balance sheet, they eliminate all the assets on their balance sheet, right? And the debt, and they can't pay the debt that's owed, right? So it's a similar process for the present creditor. Doesn't have to show that the debtor can't pay the debt that's owed. They just have to show that assets went out, they didn't come back in, so they failed to receive assets back in. The implication there is they failed to receive assets that the creditor can then get in lawsuit, and that they became insolvent. So enough assets went out such that their debts exceeded their assets. This gets a little technical. We're not trying to bring you down into the weeds with this stuff. It's just that this is what you have to prove if you can't show their frame of mind, that they got rid of assets and they either couldn't pay their bills as they came due, or they became insolvent. And what is this going to amount to? This is going to amount to two things. One is that the assets that they get back, if someone takes all of their exposed assets and put them into a self-settled trust or an LLC, like an offshore LLC or something like that, and they get back an LLC interest, the LLC interest doesn't count because the creditor cannot get to that LLC interest. If it's a protected asset that they got in exchange, it doesn't count. So when you determine whether or not they receive reasonable value or whether or not they're insolvent, They can't say, oh, the value of my LLC interest is the same as what I gave up, right? So you can prove fraudulent transfer constructively if, in fact, someone transferred all their assets and didn't get anything back that the creditor can reach. That's different offshore. We did a statute offshore that changed all that. But in terms of the U.S., that's how you prove constructive fraudulent transfer. Please send questions too if you have any doubt.
All right. So we'll move on, and we'll talk about these concepts a little bit more as we go forward, reasonably equivalent value and insolvency and so forth. Coming into a little bit of background, just where does this all come from? It's just useful. It's like a little bit part of the history component here. This notion of fraudulent transfers goes all the way back to the 1500s. This is a colorful case out of England, and the concept was carried over in English common law into the United States, and it's been a statutory concept since the early 1900s. And the reason we point this out is that the current law that we act under in several states is this Uniform Fraudulent Transfer Act from 1984 that's been adopted in nearly every state in similar form, but not the same, and is interpreted differently throughout some of the courts. But in 2014, there was a new act, a uniform, what has been termed now the Uniform Voidable, we have a misstatement there, it's actually Uniform Voidable Transactions Act, and notably what's gone from that is the word fraud and fraudulent out of the title, and the idea was to distinguish a fraudulent transfer or a voidable transfer, voidable transaction as a statutory remedy from your garden variety fraud. As Gary mentioned also, we have there were some offshore developments, and actually Gary was involved in writing this new statute in Nevis, and that's a favorable locale for some of the planning that we do.
So we have, one of the options is to fund an offshore entity. Of course, it's not really applicable for everyone, but it's a very protective way to plan through asset protection. And basically a couple years ago, there was an absence in this LLC statute in Nevis, West Indies, of fraudulent transfer law. So believe it or not, they had this beautiful LLC without fraudulent transfer provisions. So I drafted something, and what was accepted was actually very close to what we drafted. So now it does have these fraudulent transfer provisions, but they're really, really debtor friendly. So instead of between a 2 and a 4 year statute of limitations, there's really just a 1 year statute of limitations. Once someone transfers into a Nevis LLC, the creditor has 1 year to reach the asset. And they have to prove fraudulent transfer beyond a reasonable doubt. Some of the subtleties of that statute, which this is really, as you're probably realizing a lot about subtlety, is that if someone receives an LLC equity back for their transfer, that counts in the solvency calculation. And unlike the American law, which allows the creditor either prove the state of mind, the intent to avoid the creditor, or do it constructively through insolvency, the Nevis law does not allow that. The Nevis law requires the proof of intent and the proof of insolvency. And insolvency is very hard to prove because if someone received back an LLC interest or a trust beneficial interest from their Nevis entity, that counts as an asset. So it's very hard to show that they actually went insolvent. Now, what we're learning as the law develops on these offshore entities is that really the idea is that the asset protected is also offshore. We had a case, what was it, about a year ago, 18 months ago, the Wells Fargo case?
Which, BB&T?
No, the Wells Fargo where the Nevis LLC was looked at in Miami. Now, the woman really did a poor job of, it wasn't really planning, it was kind of a reactionary disaster, where she used the Nevis LLC. And if you find that a U.S. court is looking at the Nevis LLC, well, they're going to want to reach into it, and if you have assets in Florida and haven't done a very good planning job, it's probably not going to work because the courts are going to want to enforce their judgments. So in terms of our work, which we have actually quite a bit of work now going on with the foreign trust and foreign LLC law, we recommend that the assets be held offshore as well.
All right, so actually I was noticing another question that came up is how do you know when and whether Nevis law will apply? And that's another, yeah, it's a great question. Typically Nevis law will apply to actions that need to be brought in Nevis, obviously. If you have a Nevis LLC or an entity in Nevis, it's helpful to hold the assets there. So Gary mentioned this case with Wells Fargo recently, the Matthews case, where this debtor had a Nevis LLC, but the court did not apply Nevis law. The court applied Florida law
just like
to foreclose on the interest.
See, Eric says this because we talk about this all the time, because the way the statute works is that someone chooses a Nevis, a Delaware, or whatever, Florida LLC, and that LLC is kind of formed under that law. It's like a Florida nickel or a Nevis quarter, and it really, I mean, historically, that's the law that governs the kind of organizational aspects of that LLC. What we're learning is that the courts, even though the Florida LLC statute talks about Florida LLCs, not Nevis LLCs, the courts really want to apply that statute if they have a judgment against somebody who's in Florida, and that's what they did in this last case, whether it's right or not. So we don't have a clean, I don't think we have a very clean appellate decision on that. But that's a great question. We don't know. That's why we recommend having the assets offshore. We wanted to hit kind of quickly the proposed act, which we did an article, an ABA article. We can get to anybody if they want.
Okay, another good question.
Oh, we do?
Yeah, another one. This is a follow-up. Actually, this another question, same asker. Couldn't the simple fact that assets were moved to Nevis serve as evidence of intent to hide assets in a U.S. court case? In other words, what stops a U.S. court from saying, what other reason is there to send assets to Nevis other than asset protection? And that is another great
question. Yeah.
Make it even simpler. There's a case a couple years ago involving a trust where people came to Florida and hired asset protection attorneys, and some of the exhibits that were offered in that case were, well, you hired asset protection attorneys. Look at their website. They advertise asset protection. Yes, plaintiffs will try that. I haven't seen that argument made. Well, you used the Nevis LLC, but that comes back to the full, Nevis can be useful. People move assets offshore for all sorts of reasons. Asset protection being a primary one. You put some assets in a Nevis LLC. It's a
part of the plan. It's a part of the plan. And there are other reasons for other parts, and maybe this part of the plan. But it goes back to our recommendation. If you do offshore planning, try to keep the aspect of it that's foreign, keep the assets foreign. So in some ways, it doesn't really matter.
Yeah, go back to the lesson of Kilker. He said, what relevance does Kilker have? Well, yeah, it's unreported, it's old. But what did Kilker do wrong? Kilker put all of his assets into self-settled trusts in Nevada. He had no other ties to Nevada. If you take all your assets and if you have a commercial building and you try and drop that in Nevis LLC, a Florida court's going to say, well, if it's sitting on dirt here in Florida, we can go ahead and apply Florida law. Or if I'm representing the creditor in that case, I'm going to want to use whatever the most favorable law I can tie to the case is. So we use Delaware entities, and Gary does the planning. We use entities from other states and offshore.
And so we also have other intentions, and the idea is, in response to the question, is if the assets are offshore, well, does it really matter what the intentions are? Because if you have to litigate it in Nevis, you're gonna have a hard time. You're gonna have a hard time. It's just one aspect.
But the offshore entity and the offshore trust with assets offshore, the problem is for the creditor is you can't get jurisdiction here. You can't get a court here to make a decision that has any impact.
Right.
Because if your manager's in Nevis, if your trustee is offshore somewhere, you're going to have to go there. So even if it's evidence of intent, your problem is okay. You show intent, you won't be able to enforce anyway because you have to go to that jurisdiction and fight the battle. I hope that answers the question. But we welcome emails following the webinar as well. And Gary talked about, we have two other points to hit, and we wanted to talk about the new act that's going to be implemented.
Yeah, like about 16, I think it was 16 or 17 states. This is the new, this is not, the Uniform Voidable Transactions Act. It takes the place of the existing acts. It's really a revision. It really updates the current law. A lot of it is kind of a clarification of what's going on. Certain debts, for instance, that are under dispute can't be shown to make someone insolvent. Valuation still plays a major issue. One of the best changes, since we're almost out of time, we want to take some questions if you have any more, was when this stuff gets litigated and we have people in different states, the first 6 months of the case is trying to figure out what law, which Fraudulent Transfer Act applies. So if you've got people in different states and the debt's in a distinct state and you've got creditors that are all over the place, well, the creditor is trying to have the law that's very strong, where they can reach assets easily applied, and the debtor's like, no, let's use Nevada. You know what I mean? So the new act basically says, if it's an individual, it's where the debtor is. Okay, it's where the debtor individual, that state is going to govern. That law is going to govern. And if it's a business, it's a principal place of business. Eric had mentioned that they try to get rid of the word defraud, out of the Fraudulent Transfer Act by using this Uniform Voidable Transfer Act. Are we out of time?
No, I'm out of time. I want to make sure our slides match to the
discussion
here. So.
Oh yeah. That's the next. All right. Yeah. These are Eric's whipping through some of the changes that are less.
Some of the changes, but we want to talk about some of the ones that we think are most noteworthy.
So in almost every case where a creditor comes up, they confuse fraudulent transaction with fraud, and the litigation's totally different. You can get into penal aspects of fraud for misleading someone for financial benefit. That's not fraudulent transfer. Of course, now we have a Supreme Court decision that says fraud is fraudulent transfer. So we'll see the way that plays out. There are some things that it didn't do. It didn't ever define what a future creditor is. We really need to know what a future creditor is. We have Kilker. We have all these cases that says a future creditor doesn't exist if you can't identify him at the time of the transfer. But the Act protects a, quote, future creditor. We don't know why that wasn't handled. I think it's because most of the people on the committee were creditor-based, and it's very helpful to the creditor to have an ambiguous definition of future creditor.
Yeah, and what's notable here is when we read the comments to the Act, and it's been adopted, I think, introduced and adopted in about a dozen states. It hasn't been introduced in Florida yet, last I've checked. Chances are it will ultimately be introduced and adopted. But the comments talk about who's a creditor under the Act, and the comments suggest that the creditor doesn't need to be identifiable. So it'll be interesting how Florida handles that in light of the decision from the Hurlburt case, where the court focused on, well, if you have the issue of intent that you have to resolve, the question is, you have to show intent. What is the intent with respect to the creditor who's making the claim? So we have a Florida decision that essentially says the exact opposite of what the comments to the Act say, and and hopefully, if we do adopt it here in Florida, or if whatever jurisdiction, we know we have some folks outside of Florida that could be listening today. Any state that adopts this should take a look at some of these open questions. Gary mentioned this new, and I alluded to it earlier as well, this new Supreme Court case. So, we have the Uniform Voidable Transactions Act going through all the different legislatures right now with a de-emphasis on fraud, and we have the Husky International v. Ritz case, and this is a very common scenario. Ritz had a company that was sued by Husky International Electronics. He owned it in part with one or more other owners. He had an interest in the company, but he wasn't the sole owner. It was a legitimate company, but they got sued, and in the process, during that lawsuit, he caused the company to transfer assets to some other company that he had a controlling interest in. And all he did was really effectuate that, help facilitate that transfer. But that's not an uncommon thing. One company's getting sued, they move some assets over to another company. We see it with companies that have different divisions, and they try to do that. We want to do that ahead of time in the planning and structure things in a way that breaks out different divisions and reduces potential overall liability. But that's what he did. He moved assets from one company to another. He gets sued personally for a fraudulent transfer. And in the course of the lawsuit where he got sued for
bankruptcy.
Well, he got sued for fraudulent transfer and then filed for bankruptcy to try and avoid the fraudulent transfer claim. We've got Florida. We've got a recent decision in Nevada where courts have said fraudulent transfer is a statutory claim. It's not fraud. It's not a tort. In law, a tort is an intentional act.
To it.
And so there's no accessory liability. And it's not a misrepresentation of fact. Now, so we have to delve into bankruptcy law for just a second here. But in bankruptcy, you can avoid, exclude certain claims from being discharged if you can prove that the claims arose through fraudulent conduct. And that's what happened in the Ritz case. Is they sued to accept their debt from discharge. And you have to show fraudulent conduct in order to do that. This case went all the way up to the Supreme Court. The Supreme Court said a fraudulent transfer is, in fact, fraud. People will say, and commentators will say, well, that's limited to the bankruptcy context, Section 523. That's true. They made that ruling in the bankruptcy context, but when you read the ruling, their language is very broad.
Yeah.
They have no problem at all.
Claim that. There's no doubt.
And that's going to come back to places like here in Florida. We're going to see eventually. We're going to see the case where another like the UBS Payne Weber or one of these earlier cases where the lawyer or the financial advisor who's involved with a client who engages in a fraudulent transfer gets sued and is defending because the creditor says, well, yeah, we have the old cases, but now we got the Supreme Court says this is fraud. You were involved in a conspiracy to commit fraud or aiding and abetting fraud, and you're now a defendant. That's where it gets scary, and we don't know. And meanwhile, you got this Uniform Act saying, well, it's not fraud. Interesting comparison between the two, and this is something we see playing out over the next couple of years in the courts. We're into the last 8 minutes of our webinar. This is our question and answer period, so we're happy to field any other questions. But we have some additional things we can talk about while we're looking at questions. And another thing we want to hit on is what are the defenses to a fraudulent transfer? So obviously the first that should be obvious, but isn't always easy, is a legitimate supervening purpose, and basically that's a fancy way of saying
neutralize intent.
Yeah, your intent isn't asset protection, but you have other intent, other reasons for the transfer. Why might somebody go to Nevis? We have a colleague of ours that recently retired and moved to Ecuador. Maybe
that's true.
He's still a U.S. resident, but you moved to Ecuador. We have another, a business associate of ours that we work with quite a bit, who does work in South America a lot, and he has a company he works.
Or we wanted to create something for our kids offshore, and can we make the kids partial beneficiaries of this entity?
The next thing we're going to see, and we hope to do a webinar, seminar this sometime in the future, is if anybody's familiar with the cryptocurrencies and Bitcoin, and this, there's certain countries that are really ahead of the curve on this, and Estonia is really at the forefront of putting a lot of their government services on a blockchain type technology and making those available to their citizens throughout the world, and they have something now called e-residency. Well, why would you want to be an e-resident of Estonia? May give you an inside track to doing business in Europe. So there's lots of other reasons, that people will have for wanting to create entities in other locations, and we'll continue to cover those as they come up. The world is flat. That's what Thomas Friedman said, right? So that we are getting increasingly interdependent with other countries. So other defenses, a big one is statute of limitations. I think oftentimes overlooked and not as clear as it would seem on its face. There are statute of limitations defenses available to fraudulent transfer. It depends on the type of fraudulent transfer, whether actual or constructive. There is a discovery component. That means that typically the statute of limitations runs from the time a claim, from the time a transfer is made. So going back again, let's use Kilker. He made transfers in 2004, got sued in 2008. I'm not sure at what point the fraudulent transfer claim was raised, but I also don't know why they didn't raise statute of limitations defense.
Yeah, that's a clear defense there. It's very, very common, by the way. And going back to some of the questions we actually received today, you want to do your planning, you want it crisp, you want to integrate it with other things, and then you basically wait the 4-year statute, and as we do all the time, we notify banks and other creditors such that the other side of the statute doesn't get kicked in. The other side of the statute is you're either going to have a year if you're a creditor, or in Nevada, 6 months after you discover the transfer. So that's an open statute that can be closed by making a creditor or potential creditor aware of the transfer of your planning. So what you do is when you do all your structuring, you basically make your bank and everybody aware that you're doing it, and then the statute starts to run, because this is basically the #1 defense, crisp defense, where it just shuts down the whole case. That look, the time period for having made this claim is long past. This happened on a lot of the commercial and some of the residential real estate deals that went on in the big boom, where transfers were made, the lenders were made aware, and they would come back after the fact and realize that it was just too late.
Yeah, and even the statute of limitations issue isn't always clear. Different jurisdictions will treat this. Gary talked about the discovery rule. It's a creditor has 4 years from the date of a transfer, or 1 year from the time they discover the transfer, and that's why when we engage in planning, we'll recommend that you update your creditors of any planning that occurred to kind of trigger that starting point. But other jurisdictions have viewed it differently, in particular Hawaii. A fairly recent decision in 2014 or 15 out of Hawaii. Hawaii said that we'll have, and I'm going to skip forward to a slide that talks about this.
Decision.
Hawaii is actually, there's one of a few states that says we'll allow you to bring a fraudulent transfer claim within 1 year from the time you discover the fraudulent nature of the transfer. And so in that case, basically what had happened is the creditor knew that it had bank statements and had some financial documents of a debtor, knew that certain transfers had occurred, but they couldn't tell the nature of the transfer. And when they later figured out that these were transfers to insiders, and an argument came up that they were fraudulent transfers, it was well after a year that they discovered the transfers, well after 4 years from the date of the transfers. They said, well, the statute shouldn't really run, that 1 year discovery rule shouldn't run until we know the fraudulent nature of the transfer. Hawaii bought that. Washington's another state that allows that. That argument was recently made in a 2016 case in Florida, and Florida rejected that notion and said, no, it's 1 year from the date of the transfer. We put the Bell Real case up there. That's one that was cited a couple years ago in Florida for the notion that there's no fraudulent transfer statute of limitations at all. I will just say that that's, if you see that case cited or if that comes up, the decision is flawed, I believe, and not only that, but it's been interpreted. That dealt with a very unique situation against self-settled trusts, and
we're going to do an article on that.
Yeah, we're going to expand on that. It also dealt with real property versus personal property. There's a distinction in the statute,
There's another remedy that it involved that may or may not be appropriate.
So, other defenses, I don't know who came up with this in toto approach, but I kind of like it. Nest egg versus in toto. Basically, this goes, this in the valuation issues goes along with, accounting for your creditors. When you do planning, again, don't do a Stillman. Don't take all of your assets, leave yourself penniless, and put everything in a trust in another state. Leave some assets exposed, leave some assets available to pay your creditors, and that ties in these issues of valuation. And this is where valuation experts can really be handy. And we're going to do a whole seminar on valuation. And really, you have questions of what is reasonably equivalent value. How do you determine balance sheet solvency? How do you treat a contingent claim? Do you treat a contingent or disputed claim, let's say a loan guarantee, where you have a viable borrower and viable co-guarantors, and you're just one of several guarantors on a loan that has no chance of going south, and you engage in planning? Do you have to account for that whole debt as a full debt on your balance sheet? Probably not. And the recent case, 2016, BB&T v. Hamilton Greens, the argument that the fellow made in that case was one of the real estate collateral. He said, well, at the time I made my transfers, the collateral real estate that secured the loan was more than the value of the loan. So I had no reason to think I had a fraudulent transfer issue.
And there's no constructive fraudulent transfer.
So there's several defenses, and if you find yourself in a situation, or anybody does, just understand that you don't have to just throw your hands up. And finally, we have some issues at the end, and it's 1 o'clock. We don't want to keep people over time. If you have any questions after the webinar, please feel free to email either one of us, Bowman@fbl-law.com or Forster@fbl-law.com, and our contact information is available on our website here on the slide. And join our LinkedIn group, contact us on LinkedIn, and we're happy to field additional questions. Thank you for joining us today. Gary, anything final comments?
No, thanks so much. We'll be again next week with next month with the third commandment.
All right, excellent. Have a great day, everybody. Bye-bye.